Good morning and welcome to the First District Court of Appeals. We have 4 cases that are set for argument this morning. When I say your case, if the people who are arguing would please stand and state your name and your readiness to proceed. The first case today is State v. Davenport.
James Woodfield on behalf of the
John Hill on behalf of the state of Ohio. We're ready to proceed.
Okay, thank you. Next we have State versus McClanahan.
Stephanie Kessel on behalf of the appellant, I'm ready to proceed.
John Hill, also on behalf of the state of Ohio. We're ready to proceed.
Okay, thank you. And then next we have Hill Lewis et al. Versus Clifton Healthcare Center et al.
Good morning, Your Honors. Paul Flowers on behalf of plaintiff appellants, Felicia Hill Lewis.
Thank
We're
you.
ready to proceed.
Alex Freitag on behalf of Kindred and Ms. Hogan. We're ready to proceed.
Okay, thank you. And then our final case is In Re SS.
Your Honor, Daniel Monk, representing Hamilton County, representing the prosecutor's office on behalf of Hamilton County Jobs and Family Services.
Okay,
Good morning, Masha Kupka on behalf of the guardian ad litem, Amy Rodriguez, ready to proceed.
okay, and I see that the appellant is not here. I just want to remind you, and if he comes, I will remind him as well, not to use the child's name during your arguments. Just refer to the child by initials, please. Okay, I will be keeping your time. I use the light system. When you see the yellow light, you have about a minute to go. When you see the red light, that means that your time is up. Okay, the first case, if you could please come forward. Okay, Mr. Whitfield, whenever you're ready, how much time would you like to reserve? Or would you like to reserve?
5 minutes.
Okay. Okay, whenever you're ready.
Good morning. Please the court again. My name is James Whitfield. I represent appellant Kevin Davenport in this case. I should be brief, but we filed our appeal on the strong basis of the fact that the jury in this case were not given, in our opinion, proper jury instructions. They should have been given an instruction on entrapment. We believe that this case is I won't say the very definition of entrapment, but it's pretty close. According to the Ohio Supreme Court, entrapment occurs where the criminal design originates from the government, and they implant upon the mind of the defendant the disposition or the predisposition to commit an alleged offense. And that's exactly what happened in this case. I'll get into this.
Mr. Whitfield, your client had the burden to prove entrapment, correct?
That's
As an
correct.
affirmative defense?
Yes, ma'am.
What I'm wondering is, at what point were the violations complete? Because he was able to reach the weapons from where he was sitting in the car, correct?
I will say that's incorrect.
Okay. Can you explain that to me, please?
Yes, ma'am.
Thank
So and I don't want, well, just to answer your question directly, that vehicle had to be stopped. He had to reach back and undo the back seat in order to access the trunk where the weapons were. And then he had to go in the glove compartment and attempt to load the weapons. So if he was driving in a regular manner and pulled over in a basic traffic stop, he wouldn't have been able to access the weapons. They weren't ready at hand, they weren't loaded, they weren't on his lap, they weren't under his seat. If he hadn't been able to stop, given the facts of this case, if he hadn't been able to stop and actually pull over, put the car in park or neutral, whatever he did, and then reach back and retrieve the weapons, he never would have been able to get them. So the crimes that he was charged with and convicted of, he did not commit those until, I'm not sure what point he did that. The testimony, he wasn't sure, he couldn't quite remember when he stopped. He stopped 2 or 3 times at a minimum. He didn't remember if it was the second time or the third time.
But the unmarked car was simply following him, right? It wasn't, they weren't doing anything other than just driving. I just don't understand how that rises to the level of entrapment.
Because he was driving legally. He was in the area that they deemed a high crime area. He was looking for a friend. He was just driving. He had put the guns in the trunk, he put the ammunition in the glove compartment, and he felt, and I don't know how many times he'd done that in the past, but he felt that that was fine. When he noticed someone was following him, he became scared. He took evasive maneuvers. The officers testified to the fact, my client testified to the fact. He did U-turns, he stopped, he went down side streets. He stopped again, this vehicle would stop behind him. This vehicle would do U-turns behind him. He noticed that. He got scared, he became frightened. He made a decision at some point that he was going to stop and confront this individual. At no time did he know it was an officer. And then the facts get a little fuzzy, and this is beyond kind of the scope of our appeal, but it was very fortunate that no one was injured. The officer jumped out of the vehicle, according to my client's version of events, immediately started shooting at him. My client said he attempted to load his gun and shoot back, but he couldn't, which is a good thing. It worked out for the best for everyone outside of these convictions that my client's enduring. So in our position, he didn't violate the law until after the officers, even though he didn't know they were officers, but the officers did whatever they did. They followed him. They followed him for 5 to 10 minutes. Again, that's kind of iffy, the duration of this whole event. But it was clear that he tried to evade whoever he thought was following him. And officers continued to follow him. At no point did a regular police cop or a uniformed cop approach him or pull him over, because if they had, then he may not have been charged with these crimes. He may not have access to weapons. He definitely wouldn't have loaded his gun and attempted to do anything. He would have been pulled over. He testified he would have been relieved if he had gotten pulled over, but he simply had not. And from the very beginning of the case, we made it clear that entrapment was basically why we were proceeding, why we were having trial. We mentioned that in opening arguments. We discussed it during the testimony. We brought that up on record from all the officers who indicated, he wasn't doing anything illegal. There's a question whether or not he did a U-turn into a parking lot or the gas station parking lot, but he wasn't doing anything illegal.
Is there any evidence that the officers knew he had firearms in the car?
No, sir.
Then, how would they have been able to anticipate that he would have reacted that way if they didn't know he was
I don't think they
armed?
could have anticipated that, to be frank and honest, but I do think this event would have never happened if the officers had not done what they did. They didn't know, and I don't know if there's a good comparison to say this is probably minimalizing the case, but I don't know. It's not a good, I was thinking about speeding or something to that effect. If someone starts speeding, if officers in an unmarked vehicle wants to race somebody on the expressway and they start speeding and then they get pulled over. I don't know if that's entrapment or not, but if he hadn't sped because of the officers trying to race him, it never would have occurred. In this case, he never would have retrieved his weapons. He never would have tried to take evasive actions. He never would have stopped and confronted someone if he hadn't been followed by the police officers. Again, they didn't know that he had weapons. They didn't know if he had drugs. They didn't know anything. Allegedly, they were just doing their job. Apparently, they were just doing their job. It was supposed to be a loose tail. I don't think he was supposed to know that he was being followed. But obviously, the officers didn't do the loose tail very well, so he knew. And this stream of events took place. And again, it resulted in his convictions. We think that the jury should have had the chance and the opportunity to consider entrapment as a defense. And that's all we were asking for. Again, we set it up from the very beginning. Had we known we weren't be able to proceed under and use entrapment as a defense, I don't think we would have tried the case. I wouldn't advise my client to do such. I wouldn't have wasted state time, and I wouldn't be here today. But, typically the jury is supposed to be able to make that decision. That's from the Supreme Court. They're the fact finders. They should be able to consider everything, and the evidence in this case clearly pointed to entrapment.
Well, okay. Under what standard of review should we consider this?
I believe it's abuse of discretion.
Okay, so that's a higher bar than just it should have happened. That means that the trial court's decision has to be arbitrary or unreasonable.
Correct.
What was it that was presented that would make this arbitrary or unreasonable?
The fact that the crimes never would have occurred without police involvement, without police initiating this action. Again, my client wasn't involved in anything illegal. He didn't have any predisposition to do anything illegal. He wasn't looking for drugs. He wasn't looking for, he wasn't soliciting. He didn't have anything on his person, any other contraband besides the weapons. He wasn't involved in large cash. He didn't talk to anybody. The officer didn't observe anybody walk to his car or him walk to anything. He did nothing wrong.
The predisposition actually goes to the actual crime that he committed, right? I mean, it's not just predisposition to commit any crime,
That's correct.
whether or not he was predisposed to commit this
And I-
crime.
And again, I think the facts show that he wasn't. He did everything he could do to make sure that he was driving properly. He had the gun and ammunition separated. It wasn't
Until he
loaded.
realized he was getting tailed.
Until he realized he was getting tailed.
And then he decided to break the law.
And then at some point, he decided to defend himself, which resulted in him breaking the law. Yes, ma'am. He pulled over again. He reached back. He retrieved his weapons.
But this is not a self-defense issue, this is an entrapment issue, whether the police caused him to break the law.
If the police did not interact him with that day, I mean, this sounds,
Yeah, but if
Excuse me,
somebody
sir.
else would have done that, if it wasn't the police, he would have still grabbed his gun, right? I mean,
he probably wouldn't have done it.
right.
If he had been followed, and that's the whole, not the whole point, but that's important, because he wasn't followed by a private citizen, he was followed by officers. So he was entrapped. A private citizen cannot entrap a criminal defendant, but because these were officers, or an officer, like I said, doing his job, but he didn't do the tail properly, he wasn't, discreet enough, this is where we landed. And so he did take steps to defend himself. He would have taken steps to defend himself against a private citizen as you're going towards. He was 2 weeks out from retrieving or receiving his CCW at the time. He still needed a CCW. But, this court noted in one of its decisions back in 2022, I think it was State v. Rogers, carrying concealed weapon was not illegal unless he did not have a carry concealed, was a convicted felon, or otherwise legally prohibited from doing so. Mr. Davenport wasn't legally prohibited from doing what he did until his interaction with the police officers.
So you're saying he stopped the car, reached into the trunk to get the weapon,
Yes, ma'am.
and then the bullets were in the
In your glove
in the
compartment.
glove compartment. So he pulls over to grab the weapon and load the weapon.
At one point, he pulled over. He pulled over on more than one occasion. So one of those occasions, and he wasn't clear in his testimony which time that was. It could have been when they were on the viaduct. The incident actually took place on the viaduct. They started off in Camp Washington. And so I'm not sure at which point he retrieved the weapons. I don't know if he did it all in one stoppage. I don't know if at one point he got the weapons, then the next time he got the ammunition. I'm not sure how that went about, but it went about as a result of the actions of the police. Not because he was disposed or he was trying to commit some type of crime or do anything wrong. He was trying to defend himself, and I know it's not a self-defense case, it's an entrapment case. And again, but for the actions of the officers, this never would have occurred.
Mr. Whitfield, if you'd like to reserve time, your time is up.
Thank you.
Thank you.
Morning.
Mr. Hill?
Be brief here. Basically, the facts of this case are that Mr. Davenport was transporting, ready at hand where he could access it in his vehicle, a firearm, a handgun that was either loaded or clearly capable of being loaded without leaving the vehicle, and he didn't have to leave the vehicle to get it. Entrapment requires basically a deliberate inducement on behalf of law enforcement to make the defendant do something that he wasn't inclined to do. Here, the record is very clear that Mr. Davenport was carrying a gun around in his car where he could access it, and there's no evidence really that law enforcement put that idea in his head to do that. Jury instructions should only be given when they're applicable to the facts of the case. I really don't see anything in the record that would make entrapment applicable to the facts of these cases. Mr. Davenport was already committing the crimes of CCW and improper handling of firearms in a motor vehicle before he had the encounter with law enforcement. So against that backdrop, the state's position is that Judge Nestor's declining to give that instruction was not only not an abuse of discretion, which would require it to be arbitrary, unreasonable, or unconscionable, it was legally correct. So if the court has any questions, I'm happy to field them. Otherwise, I'm going to have a seat.
I do have a question. So Your argument in your brief that the crime had already occurred before they even started following him because he did have the weapons that he could reach from the car.
Correct.
So what should somebody do if they are in a car that they're able to access the trunk from the driver's seat?
Well, so what you're asking, a situation like Mr. Davenport's where it's a small compact vehicle where you can reach back. Well, I think if you have the gun in a secured container where it's locked or the ammo, I think there was probably a dispute here whether the ammo was actually separate or not.
Wasn't it found in a bag with
I
the
don't really-
larger gun? Is that correct?
That may have been the case, but I believe there was also a loaded magazine found.
Yes.
Right.
Yes.
So this was a relatively quick course of events here, right, where he pulls up on the viaduct and Officer Fox, I believe, pulls in behind him, and next thing you know, Mr. Davenport is backing up quickly in reverse, and then he hops out with the gun. I think that belies the fact that the gun wasn't already loaded. So certainly.
No, but don't we have to take, I mean, he testified, right?
Sure.
And don't we have to look at the facts in the light most favorable to the defendant when determining whether a jury instruction should be
I think
given?
what we're talking about here is an abuse of discretion, right?
Yeah.
So under that set of
But if there's a
facts-
factual dispute,
Sure.
we would have to take the facts in the light most favorable
Correct.
to him. So we would
Correct.
basically have to look at his version of the event.
That's a fair point, Judge. I
Okay.
would concede that. But the fact of the matter is, at the end of the day, he had a gun that he could render quickly operable and at hand in this particular case. So my answer to him, and as a gun owner myself, when I carry a gun around in my trunk, I've got it in a lock container with it's a lock that goes on a wire through the actual handle of the gun. And you can't, pull it out without getting out of the car, getting the key, putting it in the lock, loading the magazine. So, look, I agree with Mr. Whitfield here. This was an unfortunate set of circumstances. Obviously, Mr. Davenport had some misapprehensions about what was going on. The cops spooked him in this case. It's unfortunate, but he was already breaking the law before he had the encounter with the law enforcement.
So even if the guns prior to the encounter with law enforcement were just in the trunk, but not in a locked box in the trunk, you're saying that was, and the bullets were separate, because that was his testimony. You're saying that was breaking the law?
If what? I'm sorry, could you
Okay.
repeat that?
If we take his testimony.
Sure.
That the gun was in the trunk
Yes,
and the bullets were away from the gun in the
correct.
console or whatever,
The,
the glove
right,
compartment.
right.
Was that breaking the law at that time?
If the
Before he
gun was,
reached for
if the
them.
gun was unloaded.
His testimony, I
Right.
thought, was the gun was unloaded in the trunk and the bullets were in the glove compartment before his encounter with the police.
Correct.
Would that be breaking the law?
I would suggest yes. Under the laws that stood at that time, it was a handgun that was accessible to him. I mean, if he has a small car, he should be keeping the gun locked up in a manner where it's not readily accessible to him and easily loadable. So, yeah, I believe he was already breaking the law before he had his encounter with the cops.
Okay.
So,
Can you explain the significance of the fact that there are loaded magazines in the car?
well, I believe it certainly belies the fact that the gun was unloaded. I think the gun was probably already loaded, and this is just me speculating at this point. Obviously, as Judge Krause pointed out, we have to take the defendant's word on this, view it in the light most favorable to the defendant. But when you have a loaded magazine and an otherwise unloaded handgun, that can constitute a loaded firearm under the law. It's a gun that can be rendered operable quickly or readily. So, yep.
Thank you.
Thank you.
Mr. Whitfield, whenever you are ready, you have 5 minutes.
Thank you. So, we use the phrase "ready at hand." We're talking, that's the CCW charge. Ready at hand means to be conveniently accessible and within immediate reach, which clearly the weapons were not immediately accessible or within reach in this case, not ready at hand. So he wasn't in violation of the CCW. Again, he had to reach back into the trunk to retrieve a weapon and then try to load it. And I heard counsel indicate that the officers didn't deliberately do anything, that it wasn't their mind state. What's important in this case is the mind state of Mr. Davenport. Entrapment is subjectively based, and the jury didn't get a chance to consider that, and they should have gotten a chance to consider that. He has a right to do that. especially given the facts of this case, which raised that as an issue. And because the jury was deprived the opportunity to even consider entrapment, we don't believe that Mr. Davenport was given a fair trial. He has that right if the facts show that it should be considered. And then that goes to his mind state, and that goes to his predisposition, and that goes to whether or not he would have done what he did outside of the actions of the officers. And again, he was deprived the opportunity. So we believe that the court did abuse its discretion by not at least instructing the jury and allowing them to consider entrapment in this case and offer that as a jury instruction. Thank you.
Thank you. Thank you for your arguments. We will issue a timely decision. Okay. The next case up is State v. McClanahan. Ms. Kessler, would you like to reserve time?
I would. I'd like to reserve 8 minutes.
I'm going to give you no more than 5.
That's fine.
Okay.
May it please the court, I'm Stephanie Kessler. I represent Krista McClanahan, who is here today in court in the back row with the yellow scarf. For me, this case comes down to whether or not there are 5 instances where both conditions of direct summary contempt have been met, and I don't believe there are 5. I think the state brought up an interesting point in their brief where I think on page 4, the court warns Ms. McClanahan that she might be held in contempt. Their exchange continues for, I think, roughly 3 to 4 more statements by Ms. McClanahan before she is held in contempt. And we are conceding 1 instance of direct summary contempt, but I do think the record fails to support 5.
So she received, so it was 5 contempt convictions, but 1 punishment.
I think so. The record to me wasn't expressly clear as to whether or not it's 1 day for 1 or 1 day for 5 that's run concurrently. I couldn't quite tell.
But it was 1 day.
It was 1 day. She spent 1 night in jail.
Okay.
And if the court has any questions.
Well, which case was it appropriate for her to be in contempt on? Like, do we know that?
I don't, because there's an A, B, C, D, and an E, and from the face of the complaints that were filled out by the court, to me, they appear all identical, except for the difference in the case number. So I think our perspective is we can concede simply on case A, and it'd be the B, C, D, and E that I think aren't supported by the record.
So your concession, and let me, if I am saying this incorrectly, please correct me. So what you are saying is that her behavior as a whole justified 1 contempt, but you're saying that, I mean, she was talking over the court, and I think that's what the basis was. She was talking over the court and would not stop talking when told to. Up until the time that the trial court held your client in contempt. And then after, when the bailiff was attempting to handcuff her, she was, again, I believe, talking over the court again. Is that correct?
That's correct.
Okay. But you're saying that all equals 1 instance?
I am, because I don't think the record indicates 5 times where there's a separate imminent threat to the administration of justice such that the court couldn't carry on. Like, you do see this exchange after the contempt finding where Ms. McClanahan is making statements about jurisdiction. But you also see in that transcript that the judge is carrying on a conversation with another person. I forget the person's name, and then you see her carrying on with a second person. So I would say the fact that the court is carrying on conversations with other people during the interruptions means that those facts don't quite reach that imminent threat to the administration of justice such that the court can't continue.
But if someone is creating a disruption in court and continues to do so after, being admonished and even being held in contempt, does the judge have discretion to say, this is 1 kind of contempt contemptuous act, or this is multiple contemptuous acts.
I think the court would have, in general, in a hypothetical sense, have discretion to issue multiple contempts in one proceeding. Whereas if the judge warned a person, then said, okay, you are held in contempt, and then the person carried on with the disruptive behavior, if the judge felt that there was another imminent threat to the administration of justice, I think the judge could find a second finding.
And your argument here is that there was no delineation between like the five, so there was really just one.
Yes, Judge.
So the judge only made one finding of contempt?
I think the record supports that she felt she made one finding, but I think the complaints indicate that she found five.
Yeah, I mean, she signed 5 separate ones, right?
But were the five were based on the outbursts? Were there 5 outbursts and one finding?
I would say there are outbursts, but then there's that second prong of the direct summary contempt where the outburst has to be an imminent threat to the administration of justice. I don't think an outburst by itself necessarily gets you to direct summary contempt. So my argument is, could you count 5 outbursts, 5 statements? Yes. Can you count 5 times where there's an imminent threat to administration of justice such that the judge couldn't carry on in her view? I don't think the record supports that, the transcript. When I say the record, I
Yeah.
mean the transcript from the hearing.
Because I'm just trying to figure out if because your argument is one contempt, there was one finding where the judge said, I find you in contempt, right?
Yes,
One time.
in the transcript, yes.
And I'm trying to figure out where the judge came up with the 5 contempt charges, and it's from the 5 different outbursts.
That could be. I didn't see it that way.
It has to come from somewhere.
I think she had 5 traffic offenses that she was in court for that day. So my thought, I wasn't there, I'm not the judge.
Or so
I don't
she
wanna-
was finding her in contempt for each case.
I wonder if that is what has happened. Again, I wasn't there. There's nothing in the record that explicitly suggests that's exactly what she did, but that's what I had wondered.
Okay, so she was there for 5 separate cases, and then the judge found her one time in contempt on each case, potentially.
Potentially.
Okay.
Yes.
Got it.
And then I do think with the statements about jurisdiction, and I didn't raise this in the brief, but as I thought about it for this, there's potentially a First Amendment violation if somebody who makes a statement regarding jurisdiction, just by the nature of their statement, is held in direct summary contempt, which I think is why the law requires in part that second piece, that there has to be that imminent threat to the administration of justice. So I think the fact that somebody contests jurisdiction by itself can't be enough.
But I thought you were agreeing there was at least one instance of contempt.
There is, because I think there's one time where that second prong, that imminent threat to justice, such that the court couldn't carry on, has been met.
Okay.
I'm just saying, if she raised jurisdiction 5 times, but there's only one time where the court found there's an imminent threat to administration of justice, that's one contempt. She can't have a contempt just because she says you don't have jurisdiction in and of itself.
And she can't be found in contempt for each case if there's 5 cases.
Correct.
Right.
I think that would be unreasonable and unwarranted. And if the court has no further questions, I will see the rest of my time reserving rebuttal. Thank you.
Morning again. So I agree with Ms. Kessler. We've got here kind of a pretty thin record. It's hard to glean what exactly the trial court's thought process here was. She doesn't give much insight beyond these complaints that talk about disruptive behavior, but here was what I was able to glean from the record. I went through last night and I counted each potentially contemptuous act that Ms. McClanahan committed, and what I was able to determine, she interrupted the court at least 6 or 7 times. She questioned the court's authority 6 times, and she, in my mind, passively resisted arrest. She had to repeatedly be told to put her hands behind her back after she was told she was going to jail for contempt.
But that wasn't the basis of the contempt. On the complaint, the basis was that she talked over the court.
Right.
And I think it was talked over the court and refused to stop talking, talked over the court, and the court could not proceed without being removed, created a disturbance. So there was nothing about resisting arrest.
She didn't talk about resisting arrest. However, she did have to be told multiple times to put her hands behind her back as she continued to chirp over Judge Trotter Bratton. So there was multiple interruptions. It was all disruptive to the court's proceedings. So
Yeah, but just, I mean,
There.
I hear what you're saying, but
Yeah.
like, if someone interrupts a judge, just that act in and of itself is not contemptuous unless the judge identifies it and
Right.
says, you're in contempt
Right.
for that act.
Right, and I'm glad you brought that up. I was about to get to that, actually. Ms. McClanahan interrupted the court at least 3 times after being told to knock it off, and she questioned the court's authority 3 or 4 times after being told that she was going to be found in contempt if she continued. And I believe, as Ms. Kessler indicated and conceded in her brief, there were a number of acts that could potentially have been contemptuous. So I don't think it's fair to characterize this as one ongoing course of conduct. Certainly, I would argue, since the standard of review here is abuse of discretion, the trial court is in the best position to determine sort of the significance of any of one of these potential acts of contempt, that we should defer to her judgment in this case. I mean, certainly there's nothing in the record that would suggest that multiple.
Well, and I mean, that would work for you if she said, I have identified 5 actions of contempt, and that's why I'm imposing 5
Well, I think
penalties.
I mean, although she didn't discreetly identify them individually in the complaints, the way that the complaint is worded contemplates that Ms. McClanahan continued to engage in this conduct after being told to stop, right? I mean.
Right, but I mean, the language, I'm just looking at them, it seems identical
It is
in
identical language, that's correct.
all 5. So it's not as if there's one issue, then there's a second issue,
Right.
and there's a third issue.
Right, the point I would like to make here, and even Ms. Kessler concedes, is that there were multiple instances here where you could potentially identify discrete acts of contempt, whichever one Judge Trotter Bratton wants to point to as the proverbial straw that broke the camel's back. She doesn't really get into that. I mean, it's not clear from the record, but looking at this record, there are multiple individual acts that could potentially be construed as contempt, and given that we're talking about abuse of discretion here, the state's position is it's not arbitrary, unreasonable, or unconscionable to find multiple findings of contempt.
So you think that there were five separate contempt?
I believe that there were potentially at least 5, given that Ms. McClanahan was instructed, to stop talking, or she was going to be found in contempt, and she continued to do that. And if you look at the record, yeah, she does that more than 5 times, so perhaps Judge Trotter Bratton was being generous. I don't know. So, anyway, thank you.
Thank you.
The state points out a number of interruptions or specific comments, but again, I think this brings it back to the warning where the court gives, where she says, keep going, and you're going to walk across the street for contempt. To me, that reads as a warning for contempt. So if the judge is giving her a warning at that point, that indicates, at least in my eyes, that she has not found direct summary contempt up into that statement. After that statement, the defendant says, for contempt, yes, it is. By what authority are you acting? And after those 3 statements, the court says, all right, we'll try this again tomorrow. So after the warning, we have 3 statements that I do not think can count as 5 instances of direct summary contempt. Then we have the actual contempt finding, and then we have the conduct afterwards, none of which, to the judge's point, is listed in the complaint. So I would say there's still 1 instance of direct summary contempt here. And that's it. Thank you.
Thank you. Thank you for your arguments. We will issue a timely decision. And if the attorney for Hill Lewis versus Clifton Health Society could please come forward. Mr. Flowers, would you like to reserve time?
Yes, 3 minutes for rebuttal, Your Honor.
Okay. Whenever you're ready.
Good morning. May it please the court, I'm Paul Flowers. I represent the plaintiff appellant Felicia Hill Lewis, who's the administratrix of the estate of Louise Hill. We're here this morning on a wrongful death and survivorship action that arose out of a choking incident at the Clifton Healthcare Center. Ms. Louise Hill was a resident there. She was known to have a propensity to gorge her food and was supposed to be watched. She nevertheless had this choking episode and died a week later on January 17, 2019. This is a refiled action. In the original case, the original defendant was the Clifton Healthcare entities. Later, Defendant Rehab Care was joined, and the caption read, Defendant Rehab Care, care of Kindred Health Services Incorporated. Also joined in their individual capacities were Brianna Hogan and Sarah Evans. That case was dismissed, refiled, and then we had the current action was refiled several months later, again with the same defendants and the same caption reading for Rehab Care and Kindred Rehab Services.
Can I ask you, you know, I've read this complaint and I see not a single statement about the two defendants that are at issue here in this appeal. And I mean, what are we supposed to do with that?
Right. You're correct. The reference in the caption, obviously, not in the body. And the reason for that was at the time, on our side, counsel was not real sure what their involvement was. So it now
I
appears
mean,
they were.
that's an issue right there.
Oh, right. But they have to be joined before the statute of limitations runs.
Well,
So-
you'd filed it and you'd had time, so if you'd, I mean, but then, like, what, they moved to dismiss,
Right.
and you all never say, like, hey, here's an amended complaint that explains what they did.
Well, no, we did move to amend the complaint.
She didn't proffer a complaint.
Well, that's not required in Ohio. That's a federal rule.
Well, but you have to explain, you can't just say, like, give us another shot. Like, you have to explain exactly how you would improve upon the complaint so that us, as a reviewing court, can understand whether it was error or not for the trial court to deny
Right.
the chance.
Well, it's apparent from the text of the motion that the big change was going to be substituting Kindred Rehab Care for Rehab Care, the trade name for the actual corporation. I mean, you can't read the motion and reply and not understand that.
But again, what did they do? Like, where is that? In what document could I look to that would explain whatever the entity's name is, what did it do that provides a basis for liability?
Well, I'm not sure, first of all, anyone knows that because they were contractors. But that's not required. We don't require that kind of detail in a complaint. If they want a more definite statement under Rule 12E, they can do that. If the judge thinks there's more required, she can order the complaint to be amended. There's that. The one thing you can't do, that Rule 21 says, is you can't dismiss it for a misnomer. And again, the Supreme Court just reminded the judiciary back in 2022 that only a short, plain statement of relief is sought. And the case in particular that was
But you
Doe
still
versus
have to,
Eagles.
right, I understand that, but you still have to allege that they did something. You can't just say, this is a defendant, they're liable. Like, you have to connect those dots.
Correct. And this complaint is very detailed as to defendants collectively what happened. It doesn't parse out who's to blame for who. You have to take depots and find out whose role was for what.
It doesn't even define them as a defendant, though, in the complaint, though.
Well, it does in the caption. They're listed in the caption as defendants.
Yeah, but when the complaint lays it out, it doesn't name them,
Right.
really.
And these are, these are technical issues with the complaint that traditionally are corrected through an amendment. Now, Rule 15A does not say you have to prepare the amended complaint and show it to the judge. And that's really not possible when you don't know what the findings are going to be as to the deficiency. I mean, the judge may find there's some things wrong, there's multiple things wrong, then you correct it with the amended complaint.
So are you agreeing that the fact that they're not mentioned at all in the complaint is in fact a technical problem with the complaint? Like, it needs to be fixed in some manner to mention them, right?
Well, no, I'm thinking the complaint generally alleges defendants did this, did not do that, spells it out. What it doesn't do is parse out who did what and who's responsible for what.
So that would be what you would if you had the opportunity to amend, that's what you would fix?
If we can, if it's known. All right, that's the thing. It's not, I mean, she died at Clifton. Everybody knows Clifton's there. They got responsibilities, for sure. Clifton starts blaming Kindred at Home, who's a contractor. You can't know that until you do discovery. You can't know what Ms. Hogan was responsible and what she did, if anything. I mean, Ms. Evans has already been dropped from the case. So yeah, that's what the York decision out of the Supreme Court says, is that, you know, you can't expect the plaintiff to allege specific facts when they haven't done discovery.
Well, you have to allege facts. I mean, you do have to allege something.
Yeah, you definitely have to allege a claim. I mean, here, we're a notice pleading state. That's what the Doe versus Greenfield Schools case says. They're on notice. It's a wrongful death action arising from what happened at Clifton Manor on January 10, 2019. They have everything they need to do, to investigate it, and more can be found through discovery. Notice pleading, that's all that's required, not facts of who did what, who's responsible, and so forth.
Mr. Flores, here's where I'm struggling with, put the motion to amend aside. So in paragraph 8, what it says is, at all times herein relevant, defendants Clifton Healthcare Center and Clifton Care Center, Inc., and then it says hereinafter, defendants. And then every allegation in your complaint was about defendants. And Ms. Hogan was not included anywhere in there.
Well, right, and that's, first of all, she's included prior to that, obviously. But that's just, I think, dealing with those allegations there. I think the complaint has to be read a little more loosely than that, particularly given it's at the very beginning of the case. And it's, you know, we are supposed to be deciding cases on their merits, not technical grounds. So this is a classic situation where the opportunity to amend should have been granted, because you can't say there's no set of facts that can be proven here, which O'Brien says is required for a 12B6 motion. An amendment would give an opportunity, and if the amendment then shows that a complaint or a viable set of facts can't be alleged, then that's the proper motion for dismissal. And here, you know, our motion to amend is unopposed, right? Their only argument is futility. They don't say there'll be prejudice. They don't say it's too late. They don't say any of the things that are usually responded to that. And the judge doesn't address it. You know, she doesn't look at it one way or the other. And this court, I'm getting into my second assignment of error, though. I mean, this court has said that you have to have a rational process for denying a motion for a leave to amend. And that's the Donopoulos case versus American Trading out of here in 2016.
But I mean, this gets back to the question that I asked a few minutes ago, which is like, what did you explain to the trial court are the facts that support liability against the defendants that would then enable us or enable the trial court to make a ruling on that, enable us to review it?
Well, the whole body of the motion reads that yes, there's a misnomer apparently now between Kindred and Rehab. Obviously, that's a correction. Yes, there's no specific references to these defendants. Obviously, that's something that maybe can be put in there if discovery can confirm it. But
right there, you're saying, I don't have facts to make an allegation against this defendant. I hope that discovery will substantiate that. But like, that to me is sounding like a potential Rule 11 problem.
no.
You can't just file a complaint and say, well, I hope that discovery will
Well, Your Honor,
bear me out on that.
it's certainly not what happened. What happened is Clifton starts blaming this contractor they hired. Said, we hired these speech therapists. That's their job. Now, that's not real intuitive, that a speech therapist would be in charge of this. But if they're going to, Clifton, not them, if they're going to blame somebody, we have to get them in before the 2-year statute runs. Otherwise, you have the empty chair problem at trial. Now, our judge below did not say, hey, you need to give me more details. You need to explain to me what you need in this amended complaint. She just doesn't address that motion. And they don't oppose it other than this premature argument about it being futile. So none of that's there. So I don't understand how we could say she's got the discretion to deny it, you know, on this basis when she never goes down that road. And if she had, you know, then we could have produced that. Again, it's just all super hyper technical arguments that come up, and it happens. I've seen complaints a lot worse than this. And we amend, we revise, we get it cleared up, and we get the case back on track. That's really the nub of it. The defendants bring up an interesting argument in their brief that, hey, there's no appellate jurisdiction over this motion for leave to amend. You know, that sounds good to me. I mean, if this is going to go back to let the judge to resolve the motion for leave to amend, that's great. But we still have to reverse and vacate her dismissal with prejudice for the two defendants that are up here. That's just not viable this early in litigation on pleadings that can easily be corrected and revised. So that's an interesting issue for the court to sort out, but either way, it works out for us because we get the case back on track so it can be heard on its merits, which is what the Ohio's judiciary is expected to do. So thank you. We'd ask you to reverse.
You will have 4 minutes for rebuttal.
May it please the court. My name is Alex Freitag. I represent Ms. Hogan and Kindred. Most of the previous discussion was about the initial decision to dismiss the case. That's a pretty simple issue. The determination of who is properly in the case or who has allegations against them is determined by the body of the complaint. And as the court has picked up upon, there's no mention of either of my clients in the body of the complaint whatsoever. And in some circumstances, I would expect that you could say defendants and it would apply to everyone, but in this case, defendants is specifically defined as not my clients. And so I think I think it goes too far to say the defendant has to just change the definitions of words that are specifically just defined by the plaintiff in the complaint when reading a complaint and trying to determine the nature of the allegations against him or her. In addition, I would say that I think it's a little misleading or disingenuous to say that they need discovery to know what the allegations are. They know the basis of the treatment. They have the medical records. In fact, we went through 2 years of discovery on this case already because it's a refiled complaint. We filed a motion for summary judgment on the previous action, and they dismissed the case prior to filing a response to it. So to claim that they don't know what we did, I think is a...
So wait, discovery already happened on the first complaint?
Yes. So we went through all the way through discovery, all the way through expert disclosure, all the way through expert reports. They filed their expert report. That also did not name our client. It did not indicate any liability against us. We filed a motion for summary judgment. 28 days, I think, to the day. The day, I think the response was due that day, they voluntarily dismissed the case and then refiled it a few months later.
So the refiled complaint had a medical affidavit
Yes.
attached. And wouldn't that be included as kind of part of the whole complaint? And doesn't that medical affidavit refer to your clients?
Yeah, I don't think that that's within the body of the complaint, and I don't know that that actually indicates any violation. And there's also other issues with the affidavit of merit.
Would you consider, though, an affidavit that is attached to a complaint to be part of the complaint?
Not if it has to do with the underlying facts. I don't know that an affidavit of merit is considered part of the body of the complaint. Certainly, for instance, the civil rules allow you to file a motion for an extension of time to file an affidavit of merit. And
But doesn't it refer to your clients, the affidavit that was attached?
yes, the affidavit.
Reaching the standard of care?
Well, the affidavit of merit, if you read it, says that our clients breached the standard of care to Robert Sims. Who Robert Sims is, I don't know. Not in this case. But it never actually says in the affidavit of merit even that our clients breached any duty of care to Louise Hill, the decedent in this matter. And again, there's a lot of other, so I think that even the affidavit of merit doesn't even state what it needs to state. They do file an amended one later, but.
So it says the wrong name of the
Yeah, if you're looking at the body,
person.
if you're looking at the body of the complaint and the affidavit of merit, there's nothing that says that our client breached any duty to the decedent.
But that was amended, or that was amended later, correct? The affidavit of merit?
They filed, I don't know that the court, procedurally, I'm not sure how that stands. They filed it as an attachment to a response somewhere. I'm not sure that the court accepted it as, as a replacement or whatever. In fact, there's still a pending motion that was filed at the trial court level after we were dismissed by our co-defendant, by Clifton Healthcare, also stating that the affidavit of merit is insufficient, and that was after the amended one was filed. And so I'm not entirely sure where that stands procedurally.
But is it insufficient because it said Robert Sims instead of Hill?
That is one of the reasons it's insufficient.
Why else would it be insufficient?
Well, because there's no indication that this particular medical expert is qualified to testify about the standard of care.
So what does that matter if it's just part of allegations in a complaint? I mean, if we're just looking at the affidavit as
Right.
part of the four corners of the complaint, that's what I'm asking.
I
If
see.
it was attached and we would read that as part of the complaint, it sounds like it's pointing, and it does actually accuse your clients of breaching standard of care.
I see, okay. Yeah, I mean, with respect to purely that issue of if you change the name in the affidavit of merit, that's correct.
That would be enough to bring your clients into the lawsuit.
I disagree that the affidavit of merit is sufficient to replace the four corners of the complaint. I also,
Not to replace, but to be included within the four corners of the complaint.
well, the complaint doesn't actually say, and neither does the affidavit of merit, say what duty our client breached. It doesn't say,
Standard of care.
I mean, there's no duty, no breach, no cause. It's just a summary statement that would not survive a 12B.
So even just what's in the affidavit, despite the messing up of the names that apparently was somehow later corrected, you're saying is not enough?
Right, even if the text of the affidavit, I think if I'm understanding your question correctly, even if you took the text of the affidavit of merit and superimposed it into the body of the complaint, I don't think that that text provides sufficient basis to state a claim against.
Because it's just a conclusion, it's not the explanation of what happened.
Exactly. You have to plead facts. You don't, so just stating a summary conclusion is not sufficient to state a claim against a defendant in a case.
Okay.
With respect to the request to amend, there's really not much there, as the court picked up upon. It's just we wanted a chance to amend it to fix whatever errors the court may decide upon. They never filed a proposed amended complaint. So I still am not really sure what the allegations are.
Do they specify what errors they want to fix, though? I mean, they say they don't have to file a proposed amended complaint, so.
Yeah, and I understand. I do think that they do have to file a proposed amended complaint, first of all, for appellate review, and second of all, because for purposes of the saving statute and for the statute of limitations and everything else, the filing date is not the date that the motion to amend is filed. The filing date is the date that the proposed amended complaint is filed. And they blew that deadline. The 1 year for the saving statute is done. The 4-year statute of repose is also obviously passed. And they never filed a proposed amended complaint before then. And so it's the deadline. I mean, there's no date there where they filed it in a timely manner, which is part of the reason why amending it would be futile, because at this point we're past the statute of repose, and they can't. The case law is clear. The case Everhart case just came out a few months ago from the Supreme Court, says it's a true statute of repose. There's case law out there that suggests that you can't just even if you have a pending case and you try to add another cause of action. There's a case which is cited in the motion to dismiss, where there was a pending medical claim, which was in front of the court. The defendant or the plaintiff died. They try to add on a wrongful death case claim after the statute of repose, even though there's a pending lawsuit, and they say you can't do it. It's a true statute of repose. Appellant states several times in their briefs and their response to the motion that they did not file a medical claim. There is no medical claim in the complaint against our clients, against Ms. Hogan and Kindred. In the brief, page 7, it says, nor does the pleading confirm that a medical claim is being pursued against her, meaning Ms. Hogan, within the meaning of the revised code. And page 11, it says there are no allegations within the four corners of the complaint which would allow such a determination, referring to its medical claim, to be made. In response to the motion for summary judgment, the appellant states that first, there's no allegation in the complaint that either defendant, Hogan or Evans, qualifies as a licensed medical practitioner subject to revised code referring to the statute proposed. And I think you have to take them on their word on that. I think the complaint is clear, and they are clear, and I believe that there was no medical claim made prior to the statute proposed, because the complaint, the four corners of the complaint, even if you include the affidavit of merit, does not state a medical claim against Kindred and Ms. Hogan. And additionally, there's an argument that an amendment would relate back, and I also think that's not true. As the complaint indicates, the body of the complaint, there's only two defendants. A complaint will not relate back, even aside from the statute of proposed issue, which kind of makes this moot, but even aside from that, you can't add new parties and have it relate back. There's the Clifton defendants, they're the parties named in the complaint, they're the only parties with allegations against them in the complaint, and they can't amend it to add new people. The Supreme Court's clear on that. It can only relate back to the same, to replace entities, not to add entities. And finally, I think that whichever way you look at it, the case has to be dismissed and it has to be considered futile to try to amend it. Because the original action was for medical negligence, and I do have other problems with the complaint. I think it's vague and so forth, but the original complaint does state, original complaint meaning the initial complaint in 2020 did state a medical negligence claim, and nothing else, just a medical negligence claim. And I think that if you're looking at this new complaint, it seems to be that they're arguing that that no medical negligence claim is brought in the initial complaint, and if in this complaint, and if so, it isn't saved by the saving statute, because it has to be related to the same set of facts, the same allegations, substantially the same allegations. And if they're claiming that the initial complaint was a medical negligence case, and the new complaint's not, then it's not the same set of circumstances, and the saving statute wouldn't apply. So, if anyone has any further questions, otherwise I'll yield the rest of my time. Thank you.
Thank you.
Thank you, Your Honors. I thought I'd follow up with Judge Krause's questioning about the affidavit of merit, which in this case does specifically reference each of the defendants and conclude that they did violate the standard of care. It absolutely is part of the complaint. Civil Rule 10b-2 says, and I'm quoting, an affidavit of merit is required to establish the adequacy of the complaint. And in Fletcher versus University Hospital, the Supreme Court found exactly that. There, in that case, there was no affidavit of merit at all. And the court still held it was error to dismiss the case without prejudice. And yes, the original affidavit of merit did reference the wrong patient. That was promptly corrected. And the proper affidavit of merit that mentions or concludes with Ms. Louise Hill is attached to our memorandum in opposition to the motion to dismiss.
Did you all have discovery before the first case was dismissed?
Oh, I'm sure there was. But now we're venturing well outside the four corners of the complaint.
Yeah, but your response to my questions earlier was you need discovery to figure out like what happened. So if you had discovery before, like how was that not internalized into the actual complaint?
There was discovery. Clifton was starting to indicate that they were going to be blaming Ms. Hogan and Ms. Evans for this. Again, we're not sure we agree with that. It's a little odd. I mean, they're speech therapists, and this is a choking incident. But anyway, they were joined. The complaint was then dismissed to regroup. We start this complaint, refiled. We don't have all the discovery as to what their situations are. We may well dismiss them out, like Ms. Evans was dismissed out. But yes, it is still premature to do this. And again, I'm going into that, even though it's well beyond what this court's review is limited to, because we're just looking at the four corners of the complaint, and that includes the affidavit of merit, which is specific to these people. And again, you know, at the very least, an opportunity should be afforded to amend the complaint to correct any deficiencies, which is the Jordan versus Cuyahoga County housing case, which no one's questioning. It's a rule that exists to allow courts to get to the merits instead of resolving cases on technical grounds. And that's precisely what could happen here, because the motion and reply make it very clear that whatever deficiencies they're talking about can be fixed. We don't agree they're deficiencies. That's why we don't have an amended complaint prepared. But if the court finds that there's deficiencies, then we can correct it. And you have to know what the deficiencies are before you can file a proper amended complaint in a case like this. And certainly the very easiest thing to do would have been to substitute rehab care for Kindred Rehab, Inc., or whatever the corporate name is. That's done all the time, and that's permitted under 15C.
But you'd also have to expand the definition of defendants, right?
Well, that would be a change I would make too. It would certainly correct that. But again, it's just a technical thing, and that's certainly cured by the affidavit of merit. One thing to remember is that when they're talking about, oh no, the amended complaint's futile, it's relation back, that doesn't apply to Defendant Hogan. I mean, everyone agrees she was named, sued timely. We're not changing her name. So there is no argument that they've advanced for not amending the complaint to clear everything up against Defendant Hogan, none. With regard to rehab care, absolutely it does relate back, because we are substituting defendant rehab care with Kindred Rehab Services, Inc. That's a pure substitution. And in the Little John case out of the Supreme Court in 1988, the court said at page 101, and I quote, "The primary purpose of Civil 15C is to preserve actions which through mistaken identity or misnomer have been filed against the wrong person." And these alter ego cases happen all the time, where there's a trade name that's being used, but there's really a corporation behind it. Those are routinely corrected without this kind of fight in the Ohio courts. And one such case we cite is Dirksing versus Blue Chip Architectural Products, where the individual was allowed to be brought in after the statute of limitations had expired because he was the alter ego for Blue Chip. And obviously, he knew about the complaint. He knew it should have been against him, and so relation back applied. But again, when the whole complaint is taken together and all the circumstances, it's apparent what the allegations are. Notice pleading has been satisfied, and if it isn't, there should be an opportunity to amend to get this case back on track. So we'd ask you to reverse. Thank you.
Thank you. Okay, this case has been submitted, and we will issue a timely decision. Thank you for your arguments. So our last case is In Re SS. I don't see the appellant here, is that correct?
Your Honor, they were the two individuals that were carrying through the back of the room that left. I'm not sure if they vacated the premises completely. I don't know if the court would want me to go out and check to see if they're still here.
If they're in the
Yeah,
lobby.
if they're here, I'd prefer to allow them to argue.
Are they or not here?
Okay. Do you wish to argue anyway? Or would you prefer to submit?
Yes. Would like to submit on the briefs.
Okay. Thank you very much. Your case has been submitted, and we will issue a timely decision.